This is an article in Vox. Trump wants the Supreme Court to toss out his conviction. Will they? Hit subscribe right now. This is all over the news. They will once, hopefully before sentencing, but they will once the appeals court, the New York Court of Appeals, tells Trump's legal team that, it might take a year or so. This is blatantly unconstitutional. Hit subscribe. We'll get to that in a second. There was no federal crime. The court in New York leveled a federal crime at Trump, yet we don't know what the statute is that he broke. And that's not hyperbolic. That's the truth. We do not know the federal statute that Trump broke because he did not break a federal statute. That's why this is extremely absurd and unconstitutional. Hit subscribe to this channel right now. If you don't believe me, let's listen to Hans von Spakovsky several years back explaining that Trump did not break an FEC crime. This is a former Federal Election Commission chairman. Bradley Smith, another former chairman, stated the following as well. There is no federal crime. The misdemeanors, and you will hear from legal scholars right now explaining why it's very unconstitutional what took place. The misdemeanors in New York were elevated to felonies. The misdemeanors were past the statute of limitations. They were elevated to felonies because of a federal crime that Trump allegedly broke. The problem is that the FEC dropped the case. The FEC fined Clinton and the DNC for purchasing the Steele dossier, a compilation of lies and deceit with campaign money. The hush money case was looked at by the federal government, by the FEC and the DOJ. They dropped the case. New York decided to level a conviction against Trump based on a federal statute that's non-existent. Literally non-existent. That's why we don't know the federal crime. We know that there were the 34 record-keeping violations. The reason they're felonies is because they're elevated to an imaginary federal crime, a federal statute we don't know exists. There was no federal statute that Trump broke. That's why the court in New York, that's why nobody that's reported on it can give you the actual federal statute. This is Hans von Spakovsky at the Heritage Foundation, a former FEC chairman, stating there was no federal crime with what Trump did.
Well, a former member of the Federal Election Commission, Hans von Spakovsky, agrees with the president, and he joins us now. Hans, thanks so much for being here.
Sure, thanks for having me.
Set this up for our viewers. What is this campaign finance law, and why do you say Donald Trump did not violate it?
It's called the Federal Election Campaign Act, and it governs the raising of money and the spending of money for all federal campaigns. That's anyone running for Congress or the presidency. Mr. Cohen pleaded guilty to a supposed violation of that law because of payments that were made, I guess you could call them hush money payments, to two women who were claiming that they had had affairs with the president. The problem with his guilty plea is that those payments aren't covered by the law. The only way these kind of expenses are covered under the law is if they are campaign-related expenses. And these are liability of the president, and you actually can't use campaign funds, money that you've raised from campaign contributors, to pay for something like that.
Well, you had mentioned and quoted Federal Election Commission Chairman Brad Smith, who said that these payments to women were unseemly, but they're not necessarily illegal.
Yeah, and that's the key thing for people to keep in mind here. We're talking about what is an actual violation of federal law. And this is not something that the Federal Election Commission, and that's the independent agency that is supposed to enforce this law on a civil basis, and that's where I used to serve as a commissioner, it does not consider that these kind of payments are related to a campaign. Therefore, the rules and regulations don't apply to how that kind of a payment is made.
They literally convicted Trump on an imaginary statute that doesn't exist, or they convicted Trump without citing an FEC statute and claiming that he committed a federal campaign law violation. He broke federal campaign laws, but as you can see from Hans A. von Spakovsky, a former FEC chairman, even if they had picked that specific statute, what Trump did would not have broken the law. He's allowed to pay with his own money, Stormy. And that still wouldn't be a campaign finance issue because he would have made the personal expenditure with or without running for president. The Steele dossier, Clinton and the DNC were fined by the FEC. Unlike Trump, whose hush money case was dropped, but Clinton and the DNC were fined because the Steele dossier was purchased only because of 2016. That's what makes it a violation, using campaign funds.
Do any of Michael Cohen's or the president's actions, Hans, constitute a civil offense?
No, I don't think they do, and they certainly don't constitute a criminal offense. Why? Well, because under the law, to prove a criminal violation of the campaign finance law, you have to prove that it was a knowing and willful violation. You can't prove that when you have former FEC commissioners saying it's not a violation of the law. You have the FEC saying it's not a violation of the law. That raises great doubts about it, and so how can anyone be found to have willfully and knowingly violated the law?
Michael Cohen, he says that this was done to sway the election. So doesn't that make it campaign related, Hans?
No, it doesn't. And here's why. There's another provision of the law, and this is something that the U.S. Attorney in New York is essentially ignoring. There's another provision of the law that says that an expenditure or an expense is not campaign related if it's an expense that would exist whether or not you're running for office. And that's why this is not a campaign expense. This is the kind of claim that celebrities of all kinds get fairly often, and it was not dependent on the president running for office. Yeah, it might affect it, does not necessarily make it a campaign-related expense under the applicable statute.
Hans, one last question for you. If this case, and I hope I'm not getting you to step outside of your lane too much, but if this case isn't based on campaign finance violations, what's the case that prosecutors, you believe, have here?
Well, remember, this was only one of 4 offenses that Cohen pleaded guilty to. The more serious charges were tax evasion and financial fraud in applications that he submitted to a bank. He also pleaded guilty to lying to Congress. But the real offense here, the one that was most serious, was tax evasion. And that's why he was facing potentially a lot of time in jail because of that.
All right, Hans von Spakovsky from the Heritage Foundation, thank you so much.
So, ladies and gentlemen, that's why it is a constitutional issue. The Supreme Court can get involved when the appeals court explains to Trump and the world, well, we're going to take a year. That's too long. You need the Supreme Court to get involved before sentencing and long before November 5th. Democrats can't. Okay, they got the vapid, Pyrrhic victory of saying that Trump is a convicted felon. As you can see from Hans A. von Spakovsky, there is no campaign, there is no federal crime he committed. We know this also, there's literally no federal statute, and I explained that in my segment prior to this one. There's no federal statute he broke. We have not been given an actual federal statute. They said that he violated tax code also. We don't know the IRS code. We don't know the FEC statute. We don't know any federal statute. This is Bradley Smith, who, like Hans A. von Spakovsky and Brett Kavanaugh, just like Alito and Justice Clarence Thomas, they've already decided, in my view, when they get this, that this is not an acceptable verdict. You cannot have, this is just basic civics and a basic understanding of federalism and the Constitution. The state cannot level a federal crime. The federal government and state government can level crimes at a criminal. The state cannot rely on a federal crime that has not been leveled by the federal government yet. And that's what New York did. And it's blatantly unconstitutional. It's so absurd and ridiculous. These were record-keeping violations. Meanwhile, you have Hunter's laptop full of bribery and graft, according to the New York Post, Daily Mail, and others. I mean, you have emails asking for influence peddling, like how can you use your influence on the company's behalf is one email. Then like 10% to Joe, the big man. I mean, we can go on forever. These are obvious bribery schemes, overt graft and bribery. And then you have laptops, private servers with top secret intelligence on them that the government said, oh, well, no reasonable prosecutor would indict. The Honorable James Comey stated that, but he never explained how top secret intelligence managed to find its way or was transferred onto Clinton servers. It's impossible from a cybersecurity perspective to transfer top secret and special access program intelligence onto servers. It's the definition of criminality. It's illegal to do. You can't do that. And what Biden did was probably worse, because at least Clinton probably got tacit approval from President Obama's intel agencies or administration, which is still illegal. But with Biden, you had classified data, and he didn't have the power to declassify, neither did Clinton. Trump did have the power to declassify. So they're trying to get Trump for things that they've actually done. Case in point, the Federal Election Commission fined the Clinton campaign and the Democratic National Committee for purchasing the Steele dossier. The hush money case was dropped by the FEC. That's why we don't know the federal statute they used, because it's imaginary, it doesn't exist, or it's a statute that would easily lead to it being overturned before the Supreme Court. But let's listen to Bradley Smith. It was not a campaign finance issue. It was not a federal government crime.
So Trump's indictment looks like a perversion of campaign finance laws. There are no crimes committed, or at least that's what Bradley Smith, Capital University law professor, chairman, and founder of the Institute for Free Speech. Mr. Smith is a former FEC commissioner, and he's the co-author of Voting Rights and Election Law. Brad, you're writing in the Wall Street Journal. We've been trying to get our paws on you for the show. Thank you for coming on. You're saying there was no crime.
My pleasure.
There was no crime to start with. Even if there were some issues on the so-called filing of business papers, there was still no crime.
Right. I've had a bit more time. I had the commercial break to look at the indictment a bit more. And it looks like the last couple pages of the indictment do intend to say that the crime was not disclosing campaign contributions, although they never cite a specific government statute. But here's the problem here. The prosecutor's theory goes like this. Federal law says it's a campaign contribution to make an expenditure for the purpose of influencing a federal election. Those are the key words, for the purpose of influencing. And he says, well, these payments were intended to keep her quiet, which would help the campaign, so they were for the purpose of influencing the campaign. Now, first, these payments could have been made for other reasons, right? To prevent embarrassment to his family, to preserve marital harmony, all kinds of things. But none of that really matters, because the standard here for the purpose of influencing is not a subjective standard. It's an objective one. So if I go out and I want to pay for TV ads that say, Donald Trump is a ding-dong daddy from Dumas Bay, because I think that's really going to help him win re-election, it doesn't matter. Legally, that will not be for the purpose of influencing an election, no matter what my own subjective purpose was, right? It's subjective. So what counts as campaign expenditures? Things like, you don't hire a campaign manager unless you're running for office. Right. You don't take out ads saying vote for me unless you're running for office. You don't hire or establish field offices unless you're running for office. But other things you do. For example, you buy clothes whether you're running for office or not. So the fact that I'm running for office and I say I've got to look good, and I go out and I buy a $6,000 suit that I would never otherwise buy, doesn't make it a campaign expenditure. It doesn't count. Same if I say I need a $600 haircut. Or to take a more perhaps relevant example, suppose I'm a business owner and I say I'm going to run for office, and I go to my corporate lawyer and I say there's some lawsuits against our corporation. I think they're bogus, but let's get rid of them so they don't interfere with my run. Just settle those lawsuits. You can't settle those with campaign funds. It's not a campaign expense, even though that person's subjective purpose was to influence the campaign.
By the way,
so that's a very important part of the law.
I know. I was very impressed with the $6,000 suit. That must have been a custom, bespoke suit. In your op-ed piece, it was $4,000. But I know we've had an inflation problem in the last couple of weeks. But your point here, I'm just having some fun. But your point here, Brad, if I understand it, is that you buy a suit, you get a nice haircut, whatever. You're doing it directly for the campaign. Is that correct? That's the point you're making. But if you want to
the point is, yeah.
If you want to defend yourself, your honor, keep it away from your wife, that kind of thing, which, by the way, is unproven. I mean, Stormy Daniels keeps telling people she didn't have an affair. Nobody wants to listen to her, but that's perhaps grist for another segment. But if that does not qualify because it's not directly for the campaign. Is that right? Is that my correct interpretation?
It actually goes further than that. Even though you bought that suit because you were running for office and want it to look good, it's still not a campaign expenditure.
Oh.
Why? Because you buy clothes. You buy clothes whether you're running for office or not.
The campaign finance laws are so difficult to understand, okay, that there's no way the court in New York understood the FEC statutes. There's no way. Furthermore, we have not been given the federal statute that he broke, allegedly. The reason is because he didn't break any federal statute. That's why when you go and look, ladies and gentlemen, if you like, see if you can find a specific federal statute he broke. He did. They haven't given one to the press, to the public, to Trump, his legal team. We don't know which federal statute he broke. Furthermore, he didn't, according to the FEC. The FEC dropped the case. The Federal Election Commission, the Department of Justice dropped the case. There is no crime. So he's going to have to go to the Court of Appeals first in New York. They're going to say that it's going to take a long time, and that should be enough to get the Supreme Court to look at this. It has to look at this before November 5th, definitely before sentencing. And you'll hear there is no federal crime here. Listen to Bradley Smith, former Federal Election Commission chairman, just like Hans von Spakovsky, a former FEC chairman. And then we'll get to Brett Kavanaugh.
Right. And so anything that people might do, even if they're not running for office, doesn't count. So people pay money. For example, they pay divorce attorneys to try to seal up their divorce records so that those don't become an embarrassment of the campaign.
Right.
Their purpose may be to influence the campaign, but it's an expenditure that somebody who wasn't running for office might also make. The only things that count are things that come directly out of the fact that you're campaigning. And the flip side of this is that it's actually illegal to convert your campaign funds then to personal use. So it's actually illegal to use your campaign funds to buy that suit. It's illegal to use your campaign funds to pay a lawyer to seal your divorce records because you think that will help your campaign. And this is the real problem you have here. Not only is there, I think, not a campaign finance violation, this underlying alleged violation, but it's a situation where they're going to get Trump coming or going, because I think, knowing Bragg, and you've set the political stage very well, had Trump paid for this with campaign funds, I think we can feel pretty certain that he would be being charged today with having illegally converted his campaign funds to personal use. In other words, they were going to get him coming or going. If he pays for it with campaign funds, they were going to say it was illegal personal use. If he doesn't pay this money with campaign funds, which was the reality, now they say, oh, well, he should have used campaign funds. And that's, the antithesis of the rule of law, where you set up a system where no matter what course of action a person takes, they're going to be held in violation of it.
Also, nobody would have cared. Nobody voted for Trump over Clinton because Stormy signed a non-disclosure agreement. Nobody would have cared at all. Okay? Nobody would have cared. Not one vote would have been altered. Just like the bots and the high-tech campaign from the Kremlin. How many votes were altered? How about no votes that Democrats could say were all? They can't specify how many votes were altered. But then when Trump brings up his grievances 4 years ago, they say, well, it wasn't enough to change the outcome. So they're all over the place all the time. But listen to Bradley Smith pertaining to the federal statute that doesn't exist.
Well, I mean, but how does that get up to the Federal Election Commission, which has already turned this case down once?
Right. Well, this raises yet another question: is can, of course, a state prosecutor prosecute an alleged, quote, federal crime that the Federal Election Commission and the Department of Justice have already decided not to prosecute? We might think about it this way. Imagine if New York just passed a law saying it is a violation of the New York Penal Code to violate any federal law. And then we'll decide what federal law is violated, right? That would subvert the entire federal state structure of law. I mean, that would allow state DAs to start prosecuting anything they think is a violation of federal law, even though the federal courts or federal administrative agencies or the Department of Justice had thought it was not a violation of federal law. So it's really getting into sort of wacky legal theories, but also I think very dangerous theories. Again, if we think about the rule of law, I don't think this can be emphasized enough that if Trump had paid for these with campaign funds, which the DA says he had to have done, I think they'd probably be chasing him today for illegal conversion of campaign funds to pay this personal expense.
We don't know that Trump.
So there is no federal crime. There's no federal crime. That's what makes this unconstitutional. And I mean, you could just listen to Bradley Smith again really quickly. I mean, before we get to Kavanaugh, there is no federal crime.
No matter what course of action a person takes, they're going to be held in violation of the law.
Well, I mean, but how does that get up to the Federal Election Commission, which is...
So the FEC dropped the case. Now listen to a former FEC chairman talk about how unconstitutional this is. There is no federal crime.
Has already turned this case down once.
Right. Well, this raises yet another question: is can, of course, a state prosecutor prosecute an alleged, quote, federal crime that the Federal Election Commission and the Department of Justice have already decided not to prosecute? We might think about it this way. Imagine if New York just passed a law saying it is a violation of the New York Penal Code to violate any federal law. And then we'll decide what federal law is violated, right? That would subvert the entire federal state structure of law. I mean,
Democrats subverted the entire federal state and federal structure of law. That's exactly what Bradley Smith, the former FEC chairman, stated. That's exactly what they did. A state said that Trump broke a federal law. The federal government stated the opposite, that he didn't. That's the epitome of a constitutional quagmire, which is easily solved. Listen to Brett Kavanaugh here. He's not having the absurd argument from the special counsel. Listen to how he eviscerates the special counsel argument. He would do the same thing with a state trying to level federal charges that don't exist to Trump.
To unpack it a little more, do you agree that there are some aspects of Article 2 presidential power that are exclusive and that Congress cannot regulate and therefore cannot criminalize?
Absolutely.
Okay. For other official acts that the president may take that are not within that exclusive power, assume for the sake of argument, this question, that there's not blanket immunity for those official acts, but that to preserve the separation of powers, to provide fair notice, to make sure Congress has thought about this, that Congress has to speak clearly to criminalize official acts of the president by a specific reference. That seems to be what the OLC opinions suggest. I know you have a little bit of a disagreement with that, and what this court's cases also suggest.
So, Justice Kavanaugh, I'd like to take all of those in turn because I don't think this court's cases speak that broadly. I definitely don't think that the Office of Legal Counsel opinions stand for this broad proposition that unless the president is specifically named, he's not in the statute, and I don't think that that's necessary in order to afford adequate protection for the president's valid Article 2 functions.
When you said unless, sorry to interrupt, but I want to just get this out and you can incorporate it in the answer. You said unless there's a serious constitutional question.
Correct.
Well, it's a serious constitutional question whether a statute can be applied to the president's official acts. So wouldn't you always interpret the statute not to apply to the president, even under your formulation, unless Congress had spoken with some clarity.
I don't think across the board that a serious constitutional question exists on applying any criminal statute to the president.
The problem is the vague obstruction and 371, conspiracy to defraud the United States, can be used against a lot of presidential activities historically with a creative prosecutor who wants to go after a president.
Well, let me try to backtrack a little bit.
That's what we're talking about historically, is the risk and going forward, the risk. So you can take all of that.
I think that the question about the risk is very serious, and obviously it is a question that this court has to evaluate. For the executive branch, our view is that there is a balanced protection that better serves the interest of the Constitution, that incorporates both accountability and protection for the president. And I want to go through the protections that do exist, but perhaps it's worth returning at the outset to the statutory construction question that you raised. The Office of Legal Counsel.
So you have Kavanaugh basically stating he's not going to abide by any absurd analysis that the president is not protected under official acts simply because he was indicted. He is protected under official acts. A speech is an official act. He told people to go peacefully. So that's why they're going to give him partial immunity. I told you about the partial immunity victory that's upcoming. I told you we'd have a unanimous Supreme Court decision overturning an absurd Colorado ban. And the lovely and intelligent Alina Habba is here explaining that the Trump team's going to go to the Supreme Court. And just a matter of if, when, not if.
For former President Trump, Alina Habba, a convicted felon, because they know they're going to get it overturned on appeal. Right. I mean, Harvey Weinstein's conviction was overturned by the New York Appeals Court, but that wasn't until 4 years later. Do you guys plan to go to as high as the Supreme Court?
If we have to, we will. We have no problem with that. As you know, we've taken those.
If we have to, we will. They will have to. They want to jail Trump. Let's listen to this again. They want to jail Trump. They want him in jail because they're the ones who actually commit crimes. What better way to circumvent reality than to say, oh, look, he's actually in jail. We don't commit crimes. And Trump's an innocent man. He's been innocent of everything they've ever accused him of, and they've distorted every single quote. They've made up and fabricated stories all the time with current and former U.S. officials. They have literally made up quotes, things that he never said. They are accusing him of saying things that he never said based on anonymous sources, which is just gossip and hearsay. But anyway, let's listen to this again.
Years later, do you guys plan to go to as high as the Supreme Court?
If we have to, we will. We have no problem with that. As you know, we've taken those matters that we think are incredibly important to validating and preserving the Constitution that our country was made on. There were incredible constitutional violations in this whole proceeding, including the current gag order that's on me, the president, and anybody that works for him. It's crazy. So, look, if we care about America, we have to fight for it. And his legal team is prepared to do so in whatever way we need to do.
You know, show what Ellie Honig said, that this was a contortion and really a twist.
Focused on running the country. Instead, their focus is completely and totally on trying to take down President Trump because he has no loyalty to anybody but America. He can't be bought. Everybody knows that. He put America first. Everybody knows that. And we've got a president that today smirked in front of the camera. I mean, that says it all. The smirk to me is louder than his words. It's louder than anything else. It's not louder than the White House logs that show that state constituent DAs and AGs are visiting the White House. All of this put together says one thing. We are in trouble and we need to act now. That is November. President Trump said it. November 5th will be the real verdict, and I stand beside that.
Alina, you know, what about this? Trump lawyer Todd Blanche told Jesse Waters that prosecutors from DA Bragg's office were meeting with witnesses and talking about reviving this case starting way back in 2018. You know, the DOJ and FEC had dropped it. And boom, when Trump announced he was running for re-election in 2022, then DA Bragg launches it. What do you think?
I think it's obvious. First of all, it wasn't just DA Bragg. It was Cy Vance first. He said no. Cy Vance says no. DA Bragg says no. Mark Pomerantz, who they had come to handle this case, who is a friend of the Clintons and everybody else, comes in, is angry that they didn't bring the charges, leaves, writes a book about it, and they still don't bring it. When did they bring the charges? The minute President Trump said he was running for office, that's when they indicted him. This was past the statute of limitations. It is 8 years old. All rules don't apply when you're Trump. For crying out loud, Hochul made a rule. She made a law.
So, ladies and gentlemen, it's being addressed in every major publication. The issue of the Supreme Court is being addressed everywhere. I brought this up the second that Trump was convicted of an unconstitutional verdict. Hit subscribe if you're new to this channel. I will be here tomorrow, I would say around 4 p.m. We'll have another live stream. The Supreme Court is going to get involved. It's now a countdown. We have two major countdowns. One is the Supreme Court with hush money and with this case right here, overturning an absurd unconstitutional verdict without a federal crime. A state cannot level a federal statute at an individual without the federal government being involved. That is not even possible within our system of government. But Democrats in New York managed to do that. It's highly unconstitutional. It's even more unconstitutional than the Colorado ban that was overturned 9-0. Brett Kavanaugh will be one of the people, at the forefront of dismantling this verdict. Hit subscribe if you're new. I'll be here tomorrow at about 4 p.m. Pacific Eastern for another live stream. And God bless you. God bless America. What can I tell you? November 5th, ladies and gentlemen, is the next countdown. There's nothing they could do to stop Trump. I do fear that if they try to put him in a jail cell, that could get a certain number of people in the electorate to say, I'm just tired. I don't want to deal with the apoplectic behavior of Democrats. I like Trump, but I'm just tired of the drama. Other than that, though, I think that's their only chance. I think it's going to be a landslide victory for Trump. He is going to do something so breathtaking, amazing, historic November 5th. I think it's going to be a landslide victory. Hit subscribe. But before then, this has to be overturned by the Supreme Court. Give me